Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about another express right. Today we will look at section 80 of the Australian Constitution, the right to a trial by jury. According to section 80 of the Australian Constitution, the trial and indictment of any offence against any law of the Commonwealth shall be by jury, and every such trial shall be held in the state where the offence was committed. And if the offence was not committed within any state, the trial shall be held at such place or places as the Parliament prescribes. This provision includes what is considered to be another express right. If you are still unsure why I call them express rights or negative rights or freedoms, then you should click on the card above and watch the video that we did about the express and implied rights in the Australian Constitution. There are three elements that I want to highlight in section 80. Trial by indictment, offence against any law of the Commonwealth, and the fact that the trial will be by jury. Let's find out what this constitutional provision is all about. First, what's a trial? What's an indictment? A trial is a judicial proceeding where typically the judge will consider the culpability of an accused person by looking at the evidence and the facts related to the matter at hand. An indictment includes an information filled by the Attorney General for the prosecution of an offence. So, an indictable offence is prosecuted in the name of the Attorney General following a procedure known as information or indictment. I know, it sounds circular, I didn't make the rules. But indictment is different from a summary punishment. Some offences will be punished in a summary way. They are usually less serious. So these are offences like property damage or road traffic offences. Others, however, the indictable offences, they will be tried by jury. They are typically more serious matters like murder, manslaughter, or drug trafficking. However, in a case in 1928, it was held that the federal parliament was not required to lay down indictment procedure for all serious offences. In that case, the accused was tried summarily for an offence that attracted 1 year imprisonment. And generally this seems to be the rule. When the punishment is more than 1 year imprisonment, then we would have indictable offences. However, the decision in that case allowed for the Commonwealth to say that all offences shall be tried summarily. As Justice Higgins said, if there be an indictment, there must be a jury. But there's nothing to compel procedure by indictment. So the trial by jury is only for indictable offences, not for all serious matters. The guarantee is restricted to those offences that are tried by indictment, according to what Parliament decides is an indictable offence. This restrictive approach was later on criticised by Justice Dixon and Everett in a powerful dissent in a case called Ex parte Lowenstein from 1938. You should really read that dissent if you have the opportunity at your own time. As you know, I always leave the links to the cases that I mention in my videos in the description of the video. Until today, the High Court then adopts this restrictive interpretation of Section 80. If the offence is not triable by indictment, it does not attract Section 80, a trial by jury. Ultimately, Parliament will decide if the offence is indictable or tried in a summary way. Now, let's move to the second part, where it says that the trial by jury will happen in indictable offences against any law of the Commonwealth. An offence is just this broad term that means a public wrong. So all kinds of crimes and misdemeanors are included in this expression. And particularly here it refers to laws of the Commonwealth. So included in this expression is not only the Constitution, but any kind of act enacted by Parliament. Some even argue that it includes common law offences as well. However, there's no guarantee of a trial by jury for indictable state offences. Section 80 is not applicable to the states. This is a huge limit on the efficacy of this provision, because the bulk of the criminal law in Australia is legislated by the states. The most serious offences are usually not in Commonwealth law, but in state law. By the way, Section 80 doesn't apply to territories either. So yes, there is a restriction here for offences against any law of the Commonwealth, not of the states. But it's important to say that the states actually do have their own provisions about that. So indictable offences are usually tried by jury in all of the states. Okay, now what about jury? If you ever watched any American movie or TV series that involves law or trials, you definitely know what a jury is. Article 3, Section 2 of the United States Constitution says that the trial of all crimes, except in cases of impeachment, shall be by jury. So there's a huge difference here between the two systems, right? Between Australia and the United States. Here, a trial by jury will only happen for indictable offences against any laws of the Commonwealth. Okay, but what is a jury? A jury is a body composed of individuals responsible for determining questions of fact and applying the law to those facts in order to reach a verdict. Final decision about the existence of the offence and the culpability of the accused person. To become a juror in Australia, you need to be selected from a jury row. The members of the jury are selected from that row according to the principles of randomness and representativeness. That is, the jurors are selected from a pool of randomly selected people in a relevant area. In Brown v against the Queen from 2001, the High Court of Australia decided that there is no set number of jurors, but the number of jurors must be representative of the community and capable of performing the group deliberation that is inherent in a jury trial. 12 members is the number of an American jury, and this has traditionally been the number of members in a jury in most Commonwealth jurisdictions. But in Australia, the High Court has upheld the validity of juries with 10 and 15 members, for example. The High Court has also decided that the decisions of the jury must be unanimous. This follows the long-established common law tradition that unanimity leads to people only being convicted upon proof beyond reasonable doubt. Hey, are you liking this video? If you are, don't forget to click the like button and subscribe to our channel. That's very helpful and super important for the growth of our channel. Well, now that you've seen what this provision is all about, you may be wondering whether this is an actual express right or not. Again, I have to say that this looks much more like a limitation on Parliament and on the judiciary rather than an actual individual right. In a case called Spratt and Hermes from 1965, Chief Justice Barwick said that what might have been thought to be a great constitutional guarantee has been discovered to be a mere procedural provision. That seems to be true. And further, in Brown, the High Court of Australia decided that a person accused of an indictable offence could not waive his or her right under Section 80. So even if it was for the person's benefit, it's not possible for the accused to waive this right. Indeed, there's nothing grand about the trial by jury in Section 80. First, because the Commonwealth does not need to consider all serious offences as indictable offences. Many public wrongs can be dealt summarily. And second, because it does nothing to positively expand the legal entitlements of an individual. It is a procedural provision about how a person ought to be tried. Let's read the opinion of Justice McHugh in Chang from 2000. His Honour made a summary of how to interpret Section 80 of the Australian Constitution. Section 80 is not a great guarantee of trial by jury for serious matters. It guarantees trial by jury only when the trial is on indictment. Whether the offence is tried or triable on indictment depends in the first instance on Parliament's classification of the offence. Such a conclusion is unlikely to be accepted to many civil libertarians or those who believe that serious criminal offences should be tried by juries. But it is what our Constitution mandates. A contrary result can only be reached, in my respectful opinion, by disregarding the plain meaning of Section 80, its drafting, history, and its purpose. I hope you enjoyed learning more about the Australian Constitution. If you did, click the like button, subscribe to our channel, and hit the bell icon. And I hope to see you again soon. Until then, ciao.